Oh, hey friends, Josh Yeager, Santa Barbara dog walker and estate vault librarian. Wanted to share with you a couple of reasons in my experience why an estate plan usually doesn't work out the way everyone hoped it did. So mom and dad go to the estate planning attorney, they get the document written up, everyone thinks everything's fine. Then when we go to settle the estate, we find out there's some assets that mom and dad never put in the trust, which means those settle a different way, called probate. So if you think about it, there's three types of assets. There's the assets that mom and dad put into the bucket, the trust. There are the assets that are called non-probate assets that have beneficiary designations. Think about life insurance, IRAs, pension plans, annuities. Those don't go in the trust, nor are they probated. They have a beneficiary form that tells the world what to do with them. And then there are those things that we just forgot to put in the trust and don't have a beneficiary form, like checking accounts, like apartment buildings sometimes, like what else? Pieces of real estate, syndicated partnerships, etc. So it's an important, oh hi fellas, it's an important step to do a little audit of looking through all the things that mom and dad own and asking the question, is this already titled in the trust? Number one. Number two, if it is not titled in the trust, is it a non-probate asset, an IRA, an insurance policy, something with a beneficiary on it? And last, if it is not titled in the trust, and it's not the type of thing with a beneficiary, if it's large, let's say 180 grand or larger, why isn't it in the trust? Because you got to do a probate if the asset is of significant size, 180 grand in California. Each state has their own requirements for the maximum size to do a expedited probate just based on a signature. I see this happen all the time with people with awesome estate plans, awesome attorneys, awesome investment advisors, etc. And they just forget, oh, when we opened up that account at the local bank, we bought a couple of CDs because we wanted to get the FDIC insurance. We put it in our own name, not in the name of the trust, which means we got to probate it. Ryan and I had a case, it's currently going still actually. It's probably 6 months old now, where brother went online, bought one of the do-it-yourself trusts, and set it up. Pristine document. Really, I think the words of it are great. I think the organization's awesome. He paid a very inexpensive price to get a real high quality document. Downside was he didn't know that he actually had to change the names of the things he owned. So we're currently in probate on that one, trying to get a $300,000 Morgan Stanley investment account to the niece and nephew, because nobody did the audit. Nobody went through the discipline of gathering the data, analyzing the data, putting the data in the estate vault. So let that be a cautionary tale. Do the little review of, are the assets already titled in the name of the trust? Or are they the type of assets that should not be titled in the name of the trust? Or are they so small that they need not be titled in the name of the trust? And if they are of significant value and they are not in the trust, either get them in the trust. Really, that's really the only option. I suppose you could also set up a transfer on death. So had the brother with the JP Morgan guys decided, I don't want to put this into the trust, or I'm not going to go through the exercise of having a trust, he could have filled out some paperwork called transfer on death instruction and changed a brokerage account into a non-probate asset by having testamentary instructions in the same way that you would with an annuity or an IRA or something like that. So that's the checklist. If you want more information about these really riveting issues, you can check us out on estatevault.com. See you folks.